Good morning. This hearing will come to order. I want to welcome our witnesses and for the first time, thank you again for your appearance here, taking the time, and for your thoughtful testimony. I think this is going to be a really good hearing. It's an important hearing. Coming from a manufacturing background, coming from a business background, I certainly understand, what it's like when you're trying to run a business, when you're trying to create products, how sometimes, oftentimes, maybe universally, having to comply with federal regulations, as much as we all know we need some, takes time. And as we've seen over the decades, as we've developed layer upon layer upon layer of rules and regulation and law, sometimes often conflicting, sometimes totally contrary to one department versus the other, it creates an awful high level of uncertainty, which I think is harming economic growth. One of the things as a business person I've done a lot is strategic planning. And I can go through a quick SWOT analysis on the American economy. And let me just quick go through that. On the strength side, SWOT is strengths, weaknesses, opportunities, and threats. I'm just going to concentrate on the strengths and weaknesses side. I would say our number one strength as an economy is we're the world's largest economy. We're the world's largest customer. That is an enormous advantage in a global economic competition. Trust me, as a manufacturer, manufacturers want to be close to their customers. Our other, I think, enormous advantage is we have relatively cheap and abundant energy. Coming from, again, from a manufacturing background, if you want to manufacture products, you need power. And by and large, cheap power is better than expensive power. Now, we all want a clean environment. We need to be environmentally sensitive. But I think we can have a strong economy and a clean environment. We've got to balance the cost versus benefits of that. But the fact of the matter is, in order to have a clean environment, you need a strong economy. You have to be able to afford the luxury of the pollution controls to keep your environment clean. So we need a strong economy. Our weaknesses, certainly we have a completely uncompetitive tax situation, and Senator Portman had a great hearing here on the uncompetitive nature of our tax system in his permanent subcommittee on investigations. So we have an uncompetitive tax system. For example, if you're a global company, a global manufacturer, and you want to come and manufacture close to the world's largest customer, are you going to site your plant in Toronto with the top business tax rate of 15% or Detroit at 35%? As Senator Claire McCaskill said in that hearing, it's just math. It's simple math. We have to benchmark that. And then the whole purpose of this hearing is the regulatory environment. The cost of regulation is onerous. We can put a chart up here. There have been a number of studies by the National Association of Manufacturers, the Competitive Enterprise Institute, SBA, estimating the cost of regulation somewhere around $2 trillion per year. Now we are getting immune to these enormous numbers. People, what's $2 trillion? Just a quick aside. My wife does this all the time, but if I were to give you $1 per second, it'd take me 12 days to give you $1 million. It would take 32 years to give you $1 billion. It would take 32,000 years to give you $1 trillion. Just understand that, or those orders of magnitude, how much $1 trillion is. But another way to put it in perspective is only 9 economies in the world are larger than $2 trillion. That's the extent of a regulatory burden that we're placing on the people that we really rely on to create innovative products and services that we all enjoy, that we rely on to produce the good-paying jobs that are self-sustainable in the private sector. So we need to address that regulatory burden in a common-sense way. We need regulations, no doubt about it. We're not for the EPA. You'd still have businesses dumping benzene out their back door. So we all agree that we need regulations, but they have to be common sense. And they've got to have a very strong benefit, a high benefit versus the cost. And when you take a look at the layer upon layer, I think you can start arguing that we may be at the point, or potentially well past the point, of diminishing returns in many areas. Not all, but in many, and we have to be very careful of that. So again, I'm looking forward to the testimony, to the hearing, and the back and forth. The way we're going to do this is we have a number of senators that have introduced pieces of legislation to address the regulatory burden, and we're going to give them an opportunity to have an opening statement, but I'll first turn it over to our ranking member, Senator Carper. also ask the same unanimous consent to enter mine in the record. As long as we're doing that, I know Senator Mark Warner has a statement that he'd like to make based on his piece of legislation, so we'll also enter that in the record without objection. I do want to just speak to the event in Shanksville as well, just briefly. It was inspiring, and it is amazing. Out of that tragedy, you know, you'd get that level of inspiration. I would recommend everybody go to Shanksville and see that visitor center, listen to the messages of the voicemail message of three of the passengers to the loved ones. It's an amazing display of humanity, but it's also an amazing display of the American spirit, that story. You know, we're all aware of it, but to hear it again in the wonderful speeches that day, all I can say is it's just incredibly inspiring. So again, I really did appreciate the Secretary inviting us on that, and it was a journey well worth taking. I'd recommend it to everybody. With that, I think we'll turn it over to Senator. Thanks, Senator Langford. And again, how many times we just hear this is what we can agree on, and so I got to commend both of you as well as every member of the committee. You know, as we've gone through these committee markups and we've reported out, I think now 49 pieces of legislation, pretty much on a unanimous basis. It hasn't always been easy. You know, we've had one scheduled for a markup, and then we pull it, you know, so the parties can work with individual members as well as the administration, and we hammer out the differences and we find the area of agreement. And you also mentioned the word continuous improvement. As a manufacturer, that's just ingrained in my DNA. Continuous improvement. You may not solve the whole problem. You don't let perfect be the enemy of good. But if we can find the continuous improvement, that's the right approach. So again, I just want to really commend, again, both of you as well as the entire membership of this committee. We've been trying to find that common ground and find those areas of agreement. It is this committee swears in witnesses. It's the tradition of this committee. So if you'd both rise and raise your right hand. Do you swear the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Please be seated. Mr. Shapiro. Ranking member talked about we create these laws that are kind of like skeletons, and then we need the regulatory agencies to put the meat in the bones. I always use this example. This is I asked staff to do this about a year ago, so they're not up-to-date figures, but when previous Congresses passed the Affordable Care and Patient Protection Affordable Care Act, it was 380,000 words. A year ago, that act now is about 12 million words. So 380,000 to 12 million. Dodd-Frank, when passed, was about 350,000 words, and a year ago it was up to about 15 million words. So that's an awful lot of meat being added to the bones by the fourth branch of government that's largely unaccountable. It's unelected, and so from my standpoint, that's somewhat of a problem. Mr. Shapiro, you certainly understand the concept of productivity. I think your statement was that all the imposed new requirements, the layer upon layer, the steady accumulation of those requirements on the regulatory agencies are reducing the productivity. I mean, don't you recognize the accumulation, the layer upon layer of regulations coming out of those agencies are dramatically reducing the productivity of our economy?
Senator, I do appreciate that. Like everything in life, we need to strike an appropriate balance. And of course, people are going to differ exactly where that balance should be struck. I think sometimes it's very easy to look at regulatory costs. They're easily identified, and goodness knows those who have to bear those costs are happy to point them out. What we also have to consider, however, is that when we don't regulate, we leave in place dangers to the public. And those are real dangers. People die, people are injured, people get sick, people get cancer, on and on. People eat bad food, some of whom die. And those families, those individual families, end up paying those costs. They don't go away. They settle on someone. So we have to achieve an appropriate degree of regulation. But we can't simply look at costs. Now, I understand that there are difficulties for individual businesses. We need to strike an appropriate balance, but the productivity does have real terms, real effect on our economy and on people.
Do you know of anybody who argues we shouldn't have any regulations?
No, sir.
So we all agree, the federal government and state governments have a role in providing regulations that obviously protect the environment, protect worker safety, protect consumer safety. The argument is over what level and at what point do we hit the law of diminishing returns? I mean, do you know of anybody that doesn't want a clean environment?
Senator, I appreciate everyone's commitment to this. And as I say, we're going to disagree about where the appropriate balance gets struck. But with all due respect, I guess I have to take issue with your claim that agencies are largely unaccountable.
I didn't make that claim.
Well, people do make it. Let me give you an example. Last year, or last week or 2 weeks ago, there was an article in the Washington Post. And the Department of Agriculture wants to propose, they haven't gotten to the proposal stage yet, a rule that would eliminate one of the designations for the size of raisins. So raisins are graded like all agricultural products, and the smallest of the raisins in the regulations are called midget regulations. They were asked to get rid of that term, and they said, we're happy to do so. There is no one who disagrees with this. It's just a change of language. It's been over 2 years, and they haven't gotten to the proposed rulemaking stage because they're going through all the various analytical steps that have been imposed on them. And that's something that's uncontroversial. So I don't think from the agency's point of view, they feel like they don't do any analysis or they don't do enough analysis. They do a lot of it.
Well, I would never argue that government agencies are efficient in the way they approach things. Ms. Dudley, the BRAC Commission concept here is trying to bring some measure of subtraction to the federal government. I mean, certainly what I see is everything's additive. We are legislators, so we legislate and we just keep adding layer upon layer upon layer. I mean, at some point in time, you have to take a look and say, okay, we need to remove some of these layers. We got to clean out the garage. Can you just kind of speak to really what the concept of that BRAC Commission would be?
It actually might get to something like the raisins, because that's an example of a regulation that's in place that we need to change. And so a commission that could identify that as part of a pool of regulations that perhaps no longer serving their usefulness if it ever did, I think would be valuable. And as I mentioned briefly in the testimony, I think another value of it is what we learned from the BRAC, is that being able to vote up or down on the whole package, because otherwise it's so easy to think about what special interest it might harm if we do this versus another one, whereas if you look at it as a whole, it might be more an efficient way to do it.
One of the insights I try and provide people from the private sector, having come from it myself, is that the motivation of government agencies is the exact same thing as the private sector. They want to grow. I mean, bottom line, the difference in the private sector, in order to grow, you actually have to produce a product or a service that you can produce at a cost less than you can sell it. Okay, that's how you grow in the private sector. In government, let's face it, I mean, oftentimes not succeeding helps you to grow. You never solve that problem. You keep asking for additional resources. I mean, is that something you notice certainly in your capacity when you're in government, and just the imperative of government agencies just wanting to grow, expand their authority over the private sector?
Well, I think another difference is that in the private sector, there's that constant feedback. You have your customers' feedback. If you don't make a product that people want, you can't sell it. And so there's constant evaluation and feedback. Yes, so I think that's another advantage of the BRAC Commission, is that it would step back and have a third-party evaluation. Michael Greenstone, I think, has said to this very committee at that point, he jokes that his wife thinks he's not capable of evaluating himself accurately and he needs a third party. I think we all do.
Basically, what you're referring to in the private sector, you have the discipline in the marketplace. I mean, if you don't have a successful product that people don't want to buy, you don't produce it at a cost less than you can sell it, you go out of business, you go bankrupt. Where is that discipline in the federal government against the agencies? And isn't that really what we're trying to address here?
I think the bills that you have in front of you would address some of those things, including the, is it 1817, that would not only look back, but say, going forward, we're going to create the data or create the information that we can evaluate after the fact.
I also want to address, because I think I see this, I've been very impressed with the quality of the federal workforce, their dedication. There's no doubt about that. But that being said, I'm afraid too often in regulatory agencies, you have individuals working those agencies that have no connection, never came from the industry they're trying to regulate. And I just want, I guess, both of you to speak to the level of expertise within the agencies, the bureaucrats writing the rules within industries that they really don't understand. Which is why you need that,
right.
you know.
Anecdotally, that's what I've heard. People who've come out and tried to implement the rules, they said, oh my goodness, we had no idea. My part of the Labor Department, we had no idea what this would really be like to implement in practice.
Mr. Shapiro, would you like to comment on that?
Sure. As we all know, the rulemaking process sets up a dialogue between all interested parties. And most trade associations are only too happy to point out, let alone work with agency staff, concerning the implementation of rules and their objections to it. So agencies hear all of the time from these various components, but that doesn't mean everybody gets represented. That's why I endorse the idea of back-end review, that once the rule's in place, naturally enough, not everybody is similarly situated, and agencies ought to have the authority, if they don't already, to use various accommodation mechanisms for the particular problem of the regulated entity. We're in Alaska. You didn't take into account the weather's cold up here, and we can't possibly put in that piece of equipment. It won't work. And then the agency has to say, yeah, you're right. Let's take that into account.
Okay. Do you have something?
Just a small point. That troubles me because it seems we're moving away from the rule of law to the rule of individual exemptions, and I think it's troubling to me.
And we're not seeing necessarily that back-end review being implemented properly or fairly.
Well, and if you are, you're seeing it to people who are connected and may have
Right.
be able to get the special favors. So that troubles me because I think it's connected people get the back-end outcome.
You're not saying that sometimes large organizations have an ability to utilize a regulatory framework to disadvantage their smaller competitors? Yeah, I think that happens. Senator Carper. By the way, I wanted to commend you also for the hearing you held up in New Hampshire on heroin. We'll probably bring something back here to the committee on that as well, so appreciate your leadership on that. I do want to quick go through another round. The reason you're seeing such a bipartisan commitment to this regulatory reform is, just as Senator A pointed out, multiple times a day we hear the anecdotal evidence of businesses coming in, being threatened to be put out of business, or projects being stymied, people being subjected to conflicting regulations from different agencies, and that level of uncertainty is really hampering the ability for our economy to grow so that organizations can grow and pay good, produce good paying jobs. So this is a real problem. It really is, and that's why you're seeing the kind of bipartisan support. As an accountant, one thing that drives me nuts working with the federal government is you just don't get good information. But I agree, these things are very difficult to quantify. You have to use some common sense. And, Mr. Shapiro, we talked a little bit about accountability. Again, what I had said is largely unaccountable, and I can see where you can draw the conclusion I said unaccountable. But I do want to talk about the unaccountable nature of the fourth branch of government and how they are, in many respects, getting out of control. And we haven't talked yet about what I think is a very serious circumvention of our Constitution and really of this body of Congress, and that's the process of sue and settle. This is where, let's say, an outside group's got a problem with its environmental regulation, and they work with the regulatory agency that doesn't necessarily have the legal authority to do something. In a cooperative fashion, they sue the agency. That lawsuit goes to court, and then they settle. And what's the judge do other than say, okay, well, case dismissed, it becomes law. Ms. Dudley, would you comment on that? Because there have been multiple circumstances. I had kind of staff just give me a list of the different types of regulations that are now in force. No, from my standpoint, I think people would argue, and maybe it's a legitimate argument, no legal authority, no congressional law passed that gives them authority, but it's legally binding because the courts have ruled it so. And to me, that completely circumvents the constitutional three co-equal branches of government.
Well, and it even cuts out the president, because it's hard for the president to be aware of and in control of all those different litigations and settlements. So,
Although the president does control the agencies.
he does,
theory.
but so with their regulations, of course, it goes through a wire, and so there is that oversight. With those settlements, it doesn't go through a wire the same way, and so you even have less presidential accountability. I think it's a valid concern.
Mr. Shapiro, I really like your comment on being an administrative law professor. I mean, what are you seeing there? Does that concern you?
Not as much as you, perhaps, Senator, but that answer probably won't surprise you. Basically, agencies have a choice when they get sued. And by the way, a lot of these lawsuits are over deadlines that Congress imposed for rulemaking that the agencies find impossible to complete because of resource limitations, and then they get sued, and then they settle that they're actually going to do something. So the question before the agency is, we got sued. There's some disagreement about the way we interpret this regulation, the way we implement it, the way we enforce it. Should we go through a whole other round of rulemaking, 10 years, or should we settle this lawsuit? And I think the real objection is by people who also sue the agency, but they don't win. Or the agency forecasts they won't win, but they would have settled it some other way. This is just part of our system.
But again, your answer kind of presupposes this is actually an adversarial lawsuit. Some group is an adversary against the agency, and what we're seeing is, no, it's a completely cooperative arrangement where it's, hey, let's, we don't really have the legal authority that we can see, but, we're with you on this one, so why don't you sue us? Again, this is, obviously, my interpretation of what's happened. I mean, do you deny that that hasn't happened in the past?
It's a big government, Senator. I can't deny that lots of things happen in the government. But I don't.
You'd have a problem with that, wouldn't you?
I'd have to see the specific situation, and that's the difficulty I'm having because these things are very contextual. Does the federal government ever reach a compromise which is not a good one? Probably, but we'd have to look case by case.
Mr. Dudley, would you want to cite an example?
I'm not sure that I can cite an example, but there are law reviews that have been written about that, illustrating that problem where the agency says, we couldn't get this through our notice and comment and through our normal rulemaking process. So twist my arm, come in here and sue me on this, and we'll find a way to settle. Okay. So I think there is evidence that
Thank
happens.
you. Mr. Shapiro, you talked about, and I really did appreciate Senator Carper's question about what do we agree on. And you agreed, and you pointed to this duplication of requirements. And trust me, this committee is all about reducing duplication in all of its forms. Again, what I see is, coming here, everything is additive, which is how you get that duplication. You pass a new law, you pass a new law. So I think part of the purpose of the BRAC Commission, or we in our previous hearing, we did talk about a one-in, one-out rule. What would you recommend in terms of a process of subtraction? How would you recommend we eliminate that duplication, not only in terms of requirements on the agencies, but in terms of the regulations that have been written, the laws that have been passed, that are, again, creating that conflict, the level of uncertainty, hampering organizations, including, for example, the University of Wisconsin at Madison, whose chancellor came in and was looking for some regulatory relief. I mean, how can we reduce that duplication? What process would you use if not a BRAC or not a one-in, one-out rule?
The particular duplication to which I was referring, Senator, wasn't so much the duplication of regulations over here and over there. I've already stated I think that's a problem, and it's a difficult one. It is that agencies have all these analytical requirements, and they're different. And it would be good and more efficient if we had these in one place and Congress could decide which ones they want them to do. So, for example, there are executive orders on federalism, litigation analysis.
Okay, again, so yes, we'll stipulate there's duplication in both, there's duplication regulations on the private sector and on organizations, and there's duplication in terms of requirements on the agencies. The question is, how do we eliminate that? What process of subtraction would actually work? Because, again, everything here is a process of addition.
Well, we already engage in retrospective analysis. I'm in favor of that. I'm just against duplicative retrospective analysis. So, for example, under the Regulatory Flexibility Act, agencies, particularly OSHA and EPA, have to go back under that law, and I forgot the number of years, I think it's 8 or 10, have to look at the impact on small business every 8 or 10 years. So my point is, if Congress wants to do that another way, and that's been proposed here, then we ought to get rid of that way. So they're not having to do it for both, even if they can somehow pass the same analysis off using for the same purpose. So that's what I would.
Again, so I'm sympathetic with duplication in all its forms, you know, and we're trying to figure out a process for elimination. Ms. Dudley, can you comment on that? And, you know, are there that many examples where regulatory agencies are eliminating regulations themselves?
No. There aren't. And the retrospective review, I think, agencies are not thinking ahead to how they will do retrospective review. I think there's a difference in duplication in regulations, because if you really do have to report something one way to OSHA and another way to EPA, that really is duplication. Whereas if agencies have to report for the public record what their analysis is for different statutes, that's less duplicative. You have the same analysis and the same process.
Okay. Senator Carper. Again, I want to thank both the witnesses for the time you've taken, for your thoughtful testimony and your thoughtful answers to our questions. With that, the hearing record will remain open for 15 days until October 1st at 5 p.m. for the submission of statements and questions for the record. This hearing is adjourned.